Hello, everyone. Welcome to the Advanced Team. We've got a very special episode here today. At the beginning of the week, we're going to be digging into a little bit of actual legislation here. Our limited panel here today, I think we've got a snow day with some of our regulars, but we've got Steve Robinson, Lizzy Ryan, and joining us today is the senator from Androscoggin County, Senator Eric Brakey, Republican freshman senator. How are you guys today?
Doing great, Lynn. Thanks for having me.
Right. Okay, so Senator Brakey, thanks a lot for being here with us today. We're going to be digging into a piece of legislation that you've put forward here, but first, how's everything going up in Augusta right now?
It's going well. It's a lot to take in as a first-time legislator. At times, it can be like drinking from a fire hose, but I've been hitting the ground running. I've got 29 bills in, which is one of the bigger amounts of bills than most legislators in there. But I've got a lot of ideas, working on a lot of things, including one of the issues we're going to be talking about. Also chairing the Health and Human Services Committee, which is a big undertaking in and of itself, and we're going to have a lot of important discussions there.
That's great. Well, congratulations on your victory this fall, and I'm sure you're going to do some great things up there. The bill that we want to talk about today is, I guess, List 95, an act to eliminate cash bail. So, from what I've read about this is a bill that's meant to alleviate some of the issues, I think, with spending and overcrowding in the prison system, as well as maybe get rid of an archaic system or something you perceive as maybe being an archaic system. Senator Brakey, can you go ahead and give us the rundown on an act to eliminate cash bail?
Yeah, absolutely. Well, first let me say that we don't have the full language for this bill drafted yet. That's still going through the revisor's office, and I don't know when exactly we're going to see that. And once we do see that, there's going to probably be some initial, some further revising until we get it to a place where we're ready to really take it before the public and have public hearings on it and make it work. But the origin of this bill, this came out of conversations I had with a constituent who works in criminal justice, who's seen some of the flaws in the county jail system. This is essentially proposing that Maine adopt a model which has been already adopted in New Jersey and Washington, D.C., was advanced on bipartisan lines. In New Jersey, for example, it was Democrat-Republican support was pushed heavily by the New Jersey Civil Liberties Union and signed by Governor Chris Christie. So this is not a Republican-Democrat issue. But there are essentially a couple reasons for considering making this change. So our jail system as it is right now, there have been recent stories about prison overcrowding, huge budget shortfalls, and there's a lot of problems going on there. And one of the interesting facts about the prison overcrowding in our county jail system is that nearly 70% of all people in the county jail system are pretrial. So that means these are people who've been arrested and are awaiting a court date. And a big reason that a lot of these people are in there, even though they haven't been convicted of anything yet, is sometimes the bail amounts can be set as low as $50 for small petty crimes that they're accused of, and they simply can't come up with $50 or whatever their bail amount is set at. And the average amount it costs the taxpayers to house these individuals in our jail system is $112 a day. So we're spending hundreds and hundreds of dollars per person because they can't come up with $50 bail. Now, so the system that we're proposing would do away with the cash bail system as we think of it and replace it with a pure risk assessment based system. So when someone is arrested, there would be an assessment made on objective standards. Is this person a potential danger to other people, or is this person a flight risk? And if it's assessed on those objective standards that person is a danger or a flight risk, then you hold them. You hold them until trial, because we don't want to put dangerous people out on the streets, and we don't want to put people out who are going to disappear. But if they aren't a danger or a flight risk, why are we spending so much money keeping them in the jail system? Not to mention violating their civil liberties, because let's keep this in mind. We're a system that's supposed to be based on the premise that you are innocent until proven guilty. And in many cases, particularly people accused of small petty crimes, the amount of time that they are sitting waiting in the county jails is longer than the period of time that they would serve if they were in fact found guilty of the crime that they're accused of. So this legislation looks to find a real bipartisan win-win where we can save taxpayer money, protect civil liberties, and focus our limited resources on simply keeping those pretrial persons in jail who are a danger to others or a flight risk.
So you had mentioned New Jersey. How long did you say New Jersey had this the system in place? And are they a model? Do they have feedback yet to kind of show how it works?
It's been a couple of years since it was adopted. That we're still doing some more research into that, and we'll have that ready for when we go into public hearings.
So Lizzy Ryan, I'll go ahead and start with you. We talked about this bill very briefly in a previous episode, and you seem to have some reservations. What are your thoughts on this, or do you have some questions for Senator Brakey?
Well, no, I mean, one of my questions is I worry, sure, there's a large population of folks who are in jail who are pre-trial. My question, though, is how many of those folks are pre-trial because they couldn't afford their bail, or how many of those folks are in jail pre-trial because of the fact that they violated the requirements of their bail, because of the fact that they violated other crimes once they were released. We have a huge amount of folks who actually are released on bail and end up violating some aspects of that bail and then are sent back, and or never qualify for bail but are pre-trial because they have prior convictions and are therefore deemed a threat to society. So to me, as I'm looking at this and addressing this, thinking, okay, let's address this issue of costs in our jail system and making sure folks who are in jail should be in jail. Is this really an issue, or are we confusing pre-trial with folks who are actually rightfully in jail? Because 70% of folks who are in jail are pre-trial, but that doesn't necessarily mean they couldn't pay their bail in order to be released. And I didn't know if you had any numbers to look into that.
Senator Brakey, how would you respond to that?
Well, we're still gathering numbers, and you bring up a good question. And this is something we've talked about, that we need to do some more specific research into things to get more solid numbers. But 70% of 70% of the people in our county jail system are pretrial. Now, when we're talking about what specific portion of that 70% would be people who we would deem to release until trial on the basis that they're harmless and they're not a flight risk, we don't have those specific numbers at this point. That's going to take some more in-depth research. I've talked to some people in the criminal justice system, though, who kind of roughly estimate that it could be as much as half of those people. So then we're talking about 35%. But that's very much an estimate, and not necessarily based on hard facts. That's just talking with people in the system who are estimating that.
All right, Steve Robinson, what are your thoughts?
So I guess my first thought is that this puts an awful lot of faith in the judges, because they're the ones who will ultimately be making the decision of whether an individual can be released, or who this decision will impact. So my question is, have you talked with any of the judges to get their interpretation of how this decision might affect the way they're doing their jobs? And just as a follow-up, are you prepared to deal with the circumstances or the scenario where someone is released, someone is let go free under the provisions of this bill, and then goes out and commits some kind of heinous crime?
Well, that's always a possibility. Anyone can. That's always a possibility. But the question is, you have to look at it. You have to look at a cost benefit. Is it worth imprisoning thousands of people who are not a danger, who are harmless, and spending millions of taxpayer dollars on the off chance that there might be one person who who might do something wrong. I think that the risk assessment tools we have are going to will do a very good job of filtering that out, and we'll have a New Jersey to look at as a case study for how this has actually worked out there.
Senator, can you tell us a little bit more about the risk assessment tools? Where do they come from? Who's in charge of them? And maybe some of the criteria involved?
Well, we are still hammering out the details on that. I'm working a lot with a woman named Elizabeth Simone, who works in Maine pretrial services on that. I know I've had conversations with the Maine ACLU about these, and that's going to be part of the question and something that's going to have to hammer it out in the committee process. So there's going to be some things to hammer out there. We do want to make sure that when we are establishing these measures of risk assessment, that it's not simply something that ends up being, where the tip. The Maine ACLU brought this up, and they want to make sure, and I agree with them, that it's not something where simply someone who is of low socioeconomic status tends to fit the bill of this just on the basis of they don't have a line of credit, they don't have. I mean, these are often sometimes things that can be used to determine flight risk. How rooted are they in the community in terms of having real financial connection, financial grounding. But we hammer some of those things out.
Yeah, Lance, can I just ask just a follow-up?
Sure.
I'm supportive of this because I think it takes people out of the prisons who shouldn't be in the prisons, and it has the potential to save taxpayers money. But one concern is what happens when we do see an increase in the number of people who are let free and don't fulfill their obligations, and then the state ends up spending even more money trying to track them down and bring them in.
What obligations do you mean? Obligations in terms of showing up for
to return and go to trial. What I'm saying is, what if we end up spending even more money tracking these people down because they were in fact a flight risk and they don't want to show up to their pretrial hearings?
So there's two things there. First of all, the goal is to establish strong standards that you're making really good risk assessment on who's a flight risk and who isn't. The second thing is if there were real cases, I mean, we can explore options where it is so much cheaper and so much less of an infringement on people's civil liberties when you're talking about people who haven't been convicted of any crime. We can look at, with technology that's available today, we can look at things like ankle bracelets, for certain people if that's a real concern. That saves taxpayer money, and if there was this gray area with a particular person, these are just ideas we can hammer out in committee.
Yeah.
So Senator Brakey, I know that we already, at least in Kennebec County, we already are providing ankle bracelets in some instances. I guess my question for you is, we have a very extensive bail law that has a lot of details in it that have been sort of crafted and vetted and changed and adapted for over, a 25-year period, really. We made huge changes about 25 years ago, and if you look through the bill, changes have been made consistently throughout that time to constantly be improving the bill, and those changes have been done in coordination with prosecutors and lawyers and judges and folks involved in the criminal justice community. So I guess my question is, how much of that are you looking at, and are you keeping any aspects of that? Because there already are a lot of really good aspects that sort of help demonstrate who is fit to to leave, who might be a flight risk, who might be a risk to society. Are you building off of current law, or at least the good parts of it, if you disagree with the cash bail system? But what are you doing to sort of integrate some expertise that we already have in our laws?
I think probably a lot of that would be incorporated into whatever we establish as the risk assessment tools for the system. So if we have things that work, if we have things, keep that. If we have things that don't work, don't keep that. If there are things that need to specifically change around that because we're adopting a new model, let's change that. But just because, I will say, just because something has been done for 25 years doesn't mean that it's a working model. I mean, when we have people who are in our jail system who are there, who are can't come up with a small bail amount and are there for a longer period of time than they would serve if they were in fact found guilty, and so they simply plead guilty and take time served, regardless of whether they were guilty or not. That doesn't mean that the system, just because it's been around for a while, doesn't mean the system's working.
Well, I'm not saying that all aspects for 25 years. What I'm saying is, I mean, even as recently as 2013, that bill was amended and changed and updated to seek improvements on it. And in addition to that, this notion that folks are pleading guilty because they already served their time, I don't know that there's any way to really verify that when they went into court and pled guilty and put their own reputation at risk, sacrificing that. So they may say it, but I don't know that you can verify it.
I've talked to defense attorneys who have specifically verified that to me.
Right.
Senator
I'm sure if I
Brakey?
committed a crime, I'd say I didn't really do it too.
Senator
No,
Brakey?
no, I talked to defense attorneys who have specifically said that they have had clients who have served a longer period of time in county jail pre-trial than they would have served if they were found guilty. And so rather than mounting a defense, they simply pled guilty. Whether they were guilty or innocent, that's a question independent of this. But when we are in a situation where we are punishing people before they are convicted of the crime that they're accused of, that's a backward system.
Well, my question is, how many of those folks, and this gets back to the statistics aspect, how many of those folks were in jail pre-trial because they couldn't afford the $50 or $100 bond bail, or were they in jail pre-trial because they had prior convictions and were deemed a threat to society? To me, you know, there's a certain aspect where until you know those statistics, we can't know for sure if this is really fixing a problem or whether there are more things we need to be doing to be changing and reforming our criminal justice system. I mean, to me, the problem is recidivism, right? We have a fair amount of folks who are committing crimes and then ending up back in jail because they commit a crime again, in which case we do keep them in jail because they're deemed a threat.
See, I think
isn't it the judge right now that's, I mean, isn't it the judge that's doing their own risk assessment when they set the amount of bail? Isn't that how it works right now?
But some of it's outlined within our current law, the risk assessment, like different things to be taking into consideration, different aspects.
Steve Robinson, you had a follow-up.
Yeah, so I think Eric touched on it briefly, but this is a socioeconomic issue, and I'm a little surprised to see Lizzy be so skeptical of this bill when it's the poor people who are most harmed by this. Someone who can't afford $50 of bail because they're of such modest means, being imprisoned unfairly for too long, even if they were to plead guilty to the crime, they've already had their time served. I mean, this seems like a provision that will help low-income people. So I'm surprised that Lizzy's not jumping on board with this. This seems like an issue where the libertarian right and some of the libertarian left can come together and support this. It seems like Shenna Bellows, Rand Paul territory.
Yeah, I'm not saying it's a horrible idea. What I'm saying is there are a lot of questions that have to be answered in order to know whether it's the best way of reforming our criminal justice system. To me, as far as I can see it, we have a lot of reforms. The other thing about bail is that in addition to setting a bail, there are also requirements that go along with that bail sometimes. Sometimes it means seeking employment or being employed, or other times it means seeking certain counseling, whether it has to do with a drug-related offense. Eric, in your bill, are you still going to be taking some of those things into consideration? Perhaps there isn't a cash bail, but there are still requirements to bail. For example, seeking, getting treatment, or not talking to the victim who may be the person who is, victimized in the crime that the person may or may not have committed who's in jail. Those type of things.
Well, two things I'll say. This bill does not affect any portion of that, so that unless the committee decides to incorporate those aspects within the bill during the committee process, that should remain unchanged as the bill is currently proposed. There's going to be a lot of things to hammer out there and a lot of fine-tuning and specific detail work to do. The other thing, now you mentioned, and this is an issue that's been brought up very commonly, and I want to make sure that in the final version of the bill we are making sure that this is being incorporated. But you mentioned, conditions on someone being around the person who's maybe their victim if they are in fact guilty of something, and so that brings up kind of the domestic violence situation, which I've heard is a concern. And I do want to make sure that when we're talking about domestic violence situations, that is very much being included in that in the risk assessment of whether or not someone is a danger to other people, so that we are not putting domestic violence perpetrators back in the homes where they're committing these heinous crimes. So there's going to be a lot. As we and again, let me I stated this up front. This bill is still being drafted. We do not have final language, and it'll probably be some time before we have final language. So this is initial concept, and we're still working through the fine details of it. And I am going to be talking with judges, with sheriffs, with the Maine ACLU, with Republicans, with Democrats, and we're going to be crafting this in such a way that we are maximizing the safety of the public, the civil liberties of people who are caught in the jail system, and the most effective and efficient use of our taxpayer dollars to make sure that we are not wasting money on people who do not need to be caught in the system the way that they are.
Great. Senator Brakey, before we wrap up here, I just had one quick follow-up. Obviously, the governor is involved in a prison reform and a very big debate about that right now. Have you gotten feedback from the administration about how they feel about this and whether they think this might be a help or a hindrance to what they're trying to do?
I have not had extensive conversations. I had a very brief conversation in the halls with Governor LePage, and his big concern was wanting to make sure that, as I just mentioned, that domestic violence we're not creating a situation where domestic violence victims are going to go free. And I think that that's absolutely, I agree with him, and I think that absolutely already fits within the proposal of holding people who are deemed objectively to be a danger to other people.
All right, great. Well, we're gonna finish up by going around the horn here. Thumbs up or thumbs down on an act to eliminate cash bail, at least in concept. Lizzy, we'll start with you.
I don't have enough information. I mean, I can't get behind a bill that hasn't been drafted.
Are you pleading the fifth? Is that what you're saying?
Pleading the fifth.
All right. Steve Robinson, thumbs up or thumbs down?
I'm gonna give this one a thumbs up, Lance, and I'm also gonna give a thumbs up to the legislative approach that Senator Brakey's bringing to the table. I feel like oftentimes you see people come out of their caucus with a preconceived notion of what the bill's going to be, and they say to their colleagues, "Take it or leave it. This is what we have." But I like the fact that the senator is coming to the table and taking input from judges, from people who work in the criminal justice system, from Democrats, from Republicans, from outside interest groups across the spectrum. So I'm gonna give a thumbs up to his attitude and to the bill.
All right, great. I'm going to give this a thumbs up too. I think there's a big problem out there. I think there are a lot of civil liberty implications to this. It sounds like there's still a lot of work to be done to make sure it fits right. The concept's great. So thanks to everybody for being here. Senator Eric Brakey, thank you so much for joining us today. Lizzy Reinholt, Steve Robinson. I'm Lance Dutson for the Advanced Team. Thanks for watching. We'll catch you next time.